Welcome once again to Lehto's Law. Here's Steve Lehto.
We've got some bad news from the Supreme Court. A whole bunch of people sent me the story. This is a follow-up. I've covered this story a couple times to date. The Supreme Court has rejected the Ohio man's bid to sue the police over the arrest for the Facebook parody. Okay? So the court's decision means that police in Parma, Ohio are protected by qualified immunity in a dispute over a satirical post on Facebook. So NBCnews.com ran this version of the story sent to me by a lot of people. Lawrence Hurley wrote it. The Supreme Court yesterday turned away an Ohio man's claim that his constitutional rights were violated when he was arrested and prosecuted for making satirical posts about his local police department on Facebook. He was prosecuted, but he was found not guilty. So that's important to remember. The justice's rejection of the man's appeal means his civil rights lawsuit against the Parma, Ohio Police Department cannot move forward and is dead in the water. With its decision, the court again declined to consider revisiting qualified immunity. So they could have addressed qualified immunity by taking up this case. And by the way, don't forget, they could have taken the case up and ruled against the man and just explained their position. But they chose not to take it up at all, which means that they're saying the lower court was, in essence, right. But believe it or not, if you ask the Supreme Court, is that what you're saying? They'd say, oh, no, we just declined to hear the case because they declined to hear the vast majority of cases pitched to them. So they would just simply say, well, we're going to let that stand. We're not necessarily endorsing it. It looks like that's what they're doing, but again, we're splitting hairs, but just letting you know that's the case. So the qualified immunity here is, of course, the legal defense that allows police officers and other government officials off the hook in civil rights cases if a constitutional violation has not been clearly established at the time it occurs. So as of the moment that Facebook post went up, the parody, there was no case law in the Sixth Circuit saying that you cannot arrest somebody for putting up a parody of the police department on Facebook. And as we pointed out before, you can never get that precedent because to get the precedent would require the court to so rule, and the court cannot rule without precedent, according to the Supreme Court, who declined to hear this case and declined to explain this case. At issue in the case is whether the police officers were correctly granted qualified immunity by a lower court under the rationale that previous court precedent had not clearly established that the man's actions constituted protected speech under the Constitution's First Amendment. In March of 2016, the man set up a Facebook page that purported to be the Parma Police Department. He published 6 satirical posts during a 12-hour period, one of which claimed there was a job opening to which minorities were encouraged not to apply, and another warning people not to give money, food, or shelter to homeless people. The police department claimed the posts disrupted their operations, and they launched an investigation and ultimately searched this man's apartment and arrested him and jailed him for 4 days. He was charged under a state law that criminalizes disruption of police operations. Disruption of police operations. You cannot do something that disrupts police operations. Now, I can think of some things that would obviously be the disruption of police operations. And the question is posting a satirical web page on a social media site disrupting their operations? I wouldn't think so. But then again, I'm not on the Supreme Court. The man was acquitted at trial, and the police officers say they had probable cause to arrest the man because they genuinely believed his conduct was disrupting their operations. How is that possible, you might ask? Well, he sued the officers in the police department, saying they had violated his free speech rights as well as his right to be free of unlawful searches and seizures under the Fourth Amendment to the Constitution. After lengthy litigation, a federal judge dismissed the man's claims. The Cincinnati-based 6th U.S. Circuit Court of Appeals agreed in April of 22, ruling that the officers reasonably believed they were acting within the law, even if the Facebook page was obviously a parody. So they're saying it doesn't even matter. If they knew it was parody, it didn't matter. So that's because there's no prior court precedent saying that it's a violation of the Constitution to be arrested in retaliation for satirical remarks in a situation where the officers have probable cause. So, again, they're saying there's no precedent, and until there's precedent, we can't rule in favor of you. And what you need for precedent is a ruling in favor of your position. Therefore, it will never happen. And what drives me crazy is that many of the people who talk about qualified immunity ignore that argument. That argument is the elephant in the room. The court has set up an impossible standard. It's almost impossible. There have been a few examples, but it's so difficult to get them to say, yes, they should have been on notice of that. And it usually takes just extremely egregious cases. Qualified immunity has long been criticized for protecting officers on legal technicalities, even in situations where an obvious constitutional violation has taken place. It has often been used to protect officers faced with allegations that they've used excessive force. Qualified immunity became a key part of calls for greater police accountability in the last few years after we've had all kinds of issues and allegations involving the police. Among those backing the man's appeal was the satirical news site The Onion, which filed a light-hearted brief saying that its writers have a self-serving interest in preventing political authorities from imprisoning humorists. The Babylon Bee also filed a brief. And so the allegation, and I read several articles on this, the allegation that the police made was that the man disrupted their operations because he posted a Facebook post and created a page that caused alarm in some people who didn't get the joke. And those people called the police. And there's an interesting question that immediately raises. Do we know who those people were? Did anybody ever actually take a deposition or testimony of the people who called the police to find out, number one, if they actually existed? And number two, why do you call the police when there's a Facebook post that says, don't feed the hungry or the poor? Did you call the emergency line for that? Or did you call the non-emergency line? Why would you call the police? Now, I suppose someone's going to say, but Steve, if someone saw that and didn't catch it as parody, they're going to call the police to express their concern about the posts that the police are making and then discover that the posts weren't made by the police. So you're telling me a random phone call that would have lasted 30 seconds is disrupting police operations? Are the police operations of Parma, Ohio really so poorly run that when they get a phone call, it disrupts their operations? Is that really the case? I don't think you need parody and satire to make fun of them. That's true. If the Parma Police Department cannot handle phone calls of a general nature asking them if they've done something, then they've got bigger problems. But we're getting back to the fact that the Supreme Court has declined to hear the case. Therefore, they won't rule. They're going to let stand the ruling from the Sixth Circuit. And by the way, in case you're curious, I'm actually sitting in the Sixth Circuit right now because I am in Michigan. Michigan and Ohio are in the same circuit, the Sixth Circuit. So this is actually one that's close to home for me, figuratively speaking. I'm admitted to practice in these courts, but this is a bad result. This is a bad result. So I feel really bad for the guy, but the guy did make a very, very important point, and I'm sure the people over in the Parma, Ohio Police Department right now are celebrating that they don't have to defend that case. But again, it gets me back to the question that if they legitimately believe that phone calls made to their non-emergency number disrupt their operations, they need to rethink how their operations are put together. And by the way, if you say, Steve, what are they called 911? Well, that would be a misuse of the 911 system then, wouldn't it? You don't call 911 because you want to have a discussion with somebody about a post on a Facebook page, real or otherwise. That's not an emergency. So it's unfortunate that it ended this way, but it has in fact ended. So NBC News reported that story. Lawrence Hurley wrote it. Michael, Steve, Mark, Jake, and Lewis all sent it to me. Supreme Court rejects Ohio man's bid to sue the police over the arrest for his Facebook parody page. Questions or comments, put them below. I'll talk to you later. Bye-bye.
Thank you for watching Lehto's Law. I like long walks, especially when they're taken by people who annoy me.